This is Michael Popok, and this is Legal AF After Dark. You think you know everything you need to know about Mar-a-Lago and the prosecution against Donald Trump? Espionage Act, obstruction of justice. Did he have a classified security clearance from the Energy Department? Does it matter? Will that delay the inevitable, his trial before an election? And what is Judge Aileen Cannon actually doing right as we speak about the case? You can only find out one place on that dial, the MeidasTouch Network and Legal AF. Here's a clip.
Finally, I do want to just talk very briefly about Judge Aileen Cannon. I say briefly because there still has not been any substantive order that she has issued in a CIPA case, Classified Information Procedure Act case. And you would expect by now, with this case now pending for quite a long time, that the early CIPA deadlines would have triggered some sort of ruling on things like CIPA Section 4, where the government presents classified documents that it wants to withhold, which it has been trying to do. But recall, it took, 3 to 4 months before Judge Cannon even entered the Classified Information Procedures Act protective order under CIPA Section 3. She just kind of sat on it and asked for all this briefing and struck documents. And it took 3 or 4 months for that to happen. Then the documents were turned over. She set her own CIPA hearings that don't even comport with what the statute actually said. She's having a CIPA pre-hearing that's taking place at the end of this month. Then she's going to hold an actual CIPA hearing apparently in February, where Donald Trump's asking for access to his lawyers to have access, rather, to these CIPA Section 4 hearings to take a look at this classified information that the government wants to withhold under CIPA Section 4 and replace it with some sort of summary where the statute makes clear that the defendant nor the defendant's lawyers can be at that hearing. It's the judge and it's Special Counsel Jack Smith, but Judge Cannon is at least considering or contemplating allowing Donald Trump's lawyers to show up. So she wants to hold some pre-hearing rather than just deny it. But to me, it's more delay. And when I say there's no substantive order, if she orders, yes, Donald Trump's lawyers can be there, then Jack Smith can take an appeal. That's a substantive order on the CIPA issue, and why under the Midland Asphalt Doctrine, going back to what we talked about, why an interlocutory appeal, an appeal before the trial's over, can take place is because the statute in its text allows for interlocutory review of decisions that relate to CIPA. But Judge Cannon will just say paperless order, I'm going to schedule some pre-hearing, we'll push other dates back. That's not appealable at this stage. And that's kind of what she's been doing. But there's been all of these kind of documents that have been filed now that she's going to have to make a ruling on some of these issues. Like one of the things that Donald Trump is just filed is a motion to compel. Trump has asserted documents. Trump is asserting some kind of new theory. It's kind of like an analog to absolute immunity when it comes to classified documents. In essence, now kind of arguing, and you can see the argument kind of play out in this motion to compel, that his authority to review classified documents and declassified documents exists in perpetuity. And so that he still had that authority even when he was no longer in office. So one of the things Trump is seeking to compel are all documents relating to that made up concept, to which Special Counsel Jack Smith responded, what? What are you even talking about? That's not even a thing. We've turned over millions of documents. We've gone above and beyond our obligations. Then one of the other things Donald Trump wants, and very mischievous how kind of Donald Trump frames this, Donald Trump said a motion for leave to file a redacted brief, which you would think would mean to file that motion to compel and actually put the redactions in it. Trump saying, look, we want to protect the identities of things. But as Special Counsel Jack Smith pointed out, Trump is calling it a motion for leave to file the redacted briefing on the motion to compel. But what Trump is actually seeking to do is to disclose the identity of government witnesses, which under a statute called the Jenks Act doesn't have to be disclosed and frankly will never usually be disclosed ever until after a government's witness actually testifies at trial. Obviously, exculpatory evidence under a case and doctrine called Brady in criminal cases and under a defendant's Sixth Amendment right, all of that needs to be turned over to a criminal defendant promptly. But inculpatory evidence that would further lead to the conviction of the criminal defendant when it's Jenks material, which are these kind of government witness statements, informant types of statements, don't need to be turned over at a criminal trial, until after that witness actually testifies at the criminal trial. Special Counsel Jack Smith has turned over the Jenks material earlier to try to, move this case along promptly. But what Trump has done in this motion to compel, by coming up with that bizarre theory I told you, that he can have this authority to classify or declassify in perpetuity. But what Trump is actually trying to do in there as well is to harass and threaten the government's witnesses by unredacting their names and making their names public so all of the MAGA people can threaten them. But Trump is calling it a redacted filing. And Special Counsel Jack Smith responds, look, I'm good with transparency. I'm good with most of this stuff public, but this Jenks material, the government witnesses and informants, that can't be disclosed right now. And Trump was not requesting, this is what Jack Smith's saying, a redacted filing. He's requesting an unredacted filing, calling it a redacted filing, to disclose information that is subject to our protective order. But because Judge Cannon has created such a mess of her docket, Popok, think about all of these complicated issues that are before her now, and each of them could have been resolved promptly. Donald Trump's lawyers say they want to participate in CIPA Section 4. Denied. That's what Judge Chutkan did. Why? Because this isn't a confusing issue. Every case, you cannot show up. Your criminal defense lawyers cannot be present in there. Move on to the next one. Now she has sub-hearings and hearings on hearings, and whether or not she should allow them to do it. We're fighting over redacting or unredacting names of government witnesses, which would never be disclosed. And we haven't even got into the motions to dismiss, the dispositive motions that are going to be filed. She hasn't ruled on the motions to compel yet. She hasn't put on her calendar CIPA Section 5 hearings, which is an entire kind of very detailed hearing procedure where a criminal defendant says that they want to put classified information into a case. The government can challenge it. There's a whole process and procedure of hearings to challenge that, because the whole CIPA regime, if you will, the whole CIPA statute is to protect defendants from trying to blackmail or graymail the government and say, aha, we're going to disclose national defense information unless you dismiss the case against me. Aha, we're going to give, the names of witnesses, and we're going to harm and destroy the government unless you dismiss the case against us. So that's what CIPA tries to resolve that promptly. CIPA Section 5 disclosures by the criminal defendant, hearings on that. Then you have Judge Cannon, who's denied the government's request that Donald Trump disclose whether there's an advice of counsel defense, which it's a matter of course, if you're going to do an advice of counsel defense and blame your lawyers to keep an organized trial, the defense has to disclose if they're going to blame their lawyers or prior lawyers for the reason why they broke the law. And then they waive attorney-client privilege. So that needs to become a part of discovery. And Judge Cannon said, I'm going to wait until after dispositive motions and motions to dismiss to do that. And Donald Trump's going to come with all those frivolous motions that he brought before Judge Chutkan, which she summarily rejected, and rightfully so. But here you have Judge Cannon, who can't even read what CIPA Section 4 says, what CIPA Section 5 says. She doesn't know what the Jenks Act is, apparently. She doesn't know the difference between inculpatory or exculpatory evidence. It's basically, to round out the show, if you had Alina Habba as a judge. I mean, it's perhaps slightly better than that, but it would be like Donald Trump appointed Alina Habba in court, and Alina Habba was the one who was making rulings in important cases like this. How do you think the outcome's going to be in situations like that? The good news to all of this is that eventually the Alina Habba of the Southern District of Florida, Judge Eileen Cannon, is going to have to make a ruling. And then Jack Smith can go to the 11th Circuit and say, look, 11th Circuit, there have been errors after errors after errors, and Judge Cannon does not know what she's doing. Reverse her, and we should consider removing her, which I think will happen once Cannon actually rules, but she hasn't ruled yet. Now, finally, let me tie this up with a neat bow, though, and why I think this is actually not a bad thing at this moment, that Cannon is screwing up her own docket. There will be a time where an interlocutory appeal will be taken by Special Counsel Jack Smith before the 11th Circuit. That will then do the same thing that happened in Judge Chutkan's court. It will stay the proceedings before Judge Cannon. Paused. There will then be a briefing schedule before the 11th Circuit Court of Appeals. We will then go through that process. So I think the timing of all of this will actually be quite beneficial when this appeal to the 11th Circuit is eventually taken, when Judge Cannon finally makes a ruling, because it's going to push back that May 20th, 2024 trial date. There's also a status conference March 1, 2024, where Judge Cannon can move that trial date back. But I think Judge Cannon's so trying to protect Trump, she may still keep the trial date. But when she's reversed, it'll stay the proceedings there. I think by then we'll get the D.C. Circuit Court of Appeals decision. We're going to get what the Supreme Court's going to do on the issue of absolute presidential immunity, whether they're even going to take the case, have oral argument. And so I think it creates the sequence where you have a Manhattan District Attorney case go first. You then have the D.C. Federal case against Trump for trying to overthrow the results of the 2020 election go next. And then I think you have Cannon's case gets kicked to 2025. And I think by that time, Trump is a convicted felon, number one. And then I think in addition to being a convicted felon, I think that Cannon's errors are so egregious that Jack Smith feels comfortable and confident to ask for her removal from the case from a basic level of kind of competence, as well as constant errors. And there's some 11th Circuit case law, which we analyzed from the outset, that demonstrated that there's almost like a 3-strike rule in the 11th Circuit, at least with this one judge who made 3 massive screw-ups on sentencing. And the 11th Circuit stepped in and was finally like, okay, we're removing this judge. It's going to a new case. So comprehensive overview right there. I think I probably cannibalized the full topic there, Popok. So I'll give you just the last word generally about where we stand right now. And before you do that and give you the last word, I do want to tell everyone about an incredible new MeidasTouch feature while we have this big audience here. It's the new MeidasTouch newsletter. And it's free to sign up for our newsletter, and you get all the updates from MeidasTouch. And people have been loving this new newsletter we've been sending out. So you just go to MeidasTouch.com/newsletter, MeidasTouch.com/newsletter, sign up. It's free. And then you'll be getting emails from MeidasTouch with breaking news updates and updates from the day. And it's a great way that we stay in touch with all of the Meidas, Mighty, and Legal AFers. Once again, after the show, go to MeidasTouch.com/newsletter and subscribe. Popok, I'll give you the final word of the show.
So Alec Baldwin in the indictment there. No, I'm kidding. So let me add one thing to the Mar-a-Lago thing. My most fascinating thing for me, that he's arguing that he has Q level security clearance, and that allowed him to both obstruct justice and to commit violations of the Espionage Act. Where does the Q come from? Well, it comes from its own thing, but it's where QAnon comes from. And the person who's Q of QAnon and that rabbit hole of MAGA conspiracy theories that it used to exist only on the dark web, but it's now been mainstreamed. That person, whoever that is, supposedly had the same Q level energy department clearance as Donald Trump is claiming now. Do I really think that Donald Trump thinks he had Q level energy department classification, that he knew he had that, and that gives him carte blanche to have retained and played hide the ball with federal judges, the Department of Justice, the National Archive, Jack Smith, federal magistrates? No, I do not. I just find it's remarkable that Donald Trump finds another way to blow a dog whistle to and I'm sure there's a whole bunch of people that you and I don't associate with that are like jumping up and down and doing all sorts of hand symbols because he said Q and all of that. And by the way, that's only even if he had Q level Energy Department security clearance, it doesn't mean he had access. You still have to have a need to know that information, and he'll have to justify that. They're trying to use that to argue that it destroys his criminal mind or his mens rea, and that's all the motion practice that you just talked about. But look, though the takeaway, this has been a breathless episode. The takeaway on this one, I think, is that in the beginning of 2024, first quarter of 2024, maybe in the second quarter of 2024, we are going to see the results writ large in courtrooms with juries, with appellate courts and Supreme Court to serve justice on Donald Trump and to reestablish our criminal justice system as a proper foundation for our democratic republic. We've been waiting for this moment. We've been anticipating it. We've analyzed it. Starting 4 years ago when you and I founded this show up till today. And the payoff is coming. And I think, and we're here for it. And thank God our audience is here for it. And we can't appreciate that they're, as part of their journey, are on our journey at Legal AF. Well, if you like that kind of hard-hitting analysis, we don't pull punches, we don't blow smoke or sunshine. It's only one place on the dial. It's Legal AF. The title is exactly what you think. It's every Wednesday and Saturday at 8 p.m. on the MeidasTouch Network. Free subscribe. Help them get to 2 million. They're going to hit 2 million this month, and you can be part of that movement. And then if you know all about Legal AF, then take that clip as an appetizer, as a teaser, send it to friends or family or people in your life and ask them to join our journey. If you have no idea who I am or what I'm talking about, I'm Michael Popok. That was Legal AF. And we invite you to join us on Wednesdays and Saturdays, 8 p.m. on YouTube, right here on this channel, and on audio podcast platforms of your choice. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.